Morning, everyone. I'm just going to give it a few moments just to allow people to join as I've just started the webinar. I can see people joining now, so that's fantastic. Okay, I can see the numbers creeping up there, so we'll make a start whilst other people join. So good morning and welcome to our September webinar. For those who don't know me, I'm Emma O'Connor. I'm a director in the employment team, and I'm thrilled to be joined today by Katie Harris, who is a senior associate in our team. And it's great that Katie can join me today. Now, many of you are probably thinking after last week's budget, my goodness me, what are they going to talk about? But being the unflappable lawyers that we are, never fear, we are all prepped and ready. And actually, despite the government's announcement last week that there's going to be, rethink to the whole IR35 regime, actually, it is still incredibly relevant to employers, and the issue of status will continue to be incredibly relevant to end users and to clients. So, there is still a lot that we need to focus on internally in our recruitment and in the way that we engage people within our businesses. Just a bit of housekeeping. We are live, so please do bear with us if there are any issues, but I don't expect there to be. And as always, if you've got any issues, then please can you post those in the chat, and we will do our best to cover off any questions as we go through. If anything is a little technical, might take a little bit longer to deal with, or very specific to your business or your situation, then we will deal with that offline. So do please post it in the chat, and then we can pick that up after the webinar. As ever, this is an overview of the core themes. So again, it is no substitute for taking your own advice. And as we saw last week, the law is in a constant period of flux. So if there are any sort of pressing issues, then please do take specific advice. So what are we going to be talking about today? Well, we're going to have a recap on what IR35 is and how it works, sort of the theory versus the practice. We're then going to have a look at some developments, particularly in terms of case law. We've seen some pretty high profile cases. I'm sure many of you you've come across those in the press. So it's going to be very interesting to see how those cases have impacted on some of the trends, the challenges, and also criticisms of IR35. Then we are going to have a look at perhaps sort of entering a brave new world of post-budget, and also some new legislation to watch out for, which could potentially have a huge impact on the landscape of workers and employee rights in the UK. So huge development there again last week, big week last week. And then we'll have a little talk about where we see things as well, and that those sort of themes will come up as we work our way through today's webinar. So let's make a start. Lots to talk about, lots been happening. So I think the first issue, Katie, and one I think it would be useful to do, is to just give us a bit of an overview in terms of IR35 and what it all means.
Yes, definitely. I think it's just helpful to have that little reminder of what exactly IR35 is and what it does. So IR35 is actually a nickname for a piece of legislation. I think that the term IR35 originated from the form actually that people had to use to declare their tax, and it stuck. And what this piece of legislation does is it's designed to prevent what HMRC call disguised employment. So this is where individuals will use limited companies to provide their services through as a way of, it's not a form of tax avoidance, but I suppose tax efficiency to reduce the tax cost to both them and their employers. And the way that would work is that because the client, or the employer if you like, is contracting directly with a limited company, it in theory doesn't have to make payroll or income tax deductions, and instead would just pay the company gross. The contractor would be an employee of their own company. They would pay themselves a very nominal salary and would take the rest of their income through dividends, which obviously is subjected to a much lower sort of tax rate than the income tax. And the purpose of IR35 was that the HMRC and the government cottoned on to the use of limited companies in this way as a bit of a loophole to avoid accounting for income tax. And the principle that they sort of maintained is that people who are in fact acting as employees and working as employees should be taxed like employees, despite the fact that they may be operating through their own limited companies. And I think this intention is summarised quite neatly by the government's own explanation, which is in italics there, that the intention behind the intermediaries rules, which is IR35, is to ensure that where a worker works for a client in a way that would have been employment, but for the existence of the intermediary, and by intermediary we mean they're a limited company, that tax and national insurance contributions are deducted from their income at a similar rate as a comparable employee. So that's the purpose of the legislation and what it is intending to do. So if we can move on to the next slide, Emma, just to sort of explain this a bit further. So IR35 has been around for a long time. It's a misconception that this is a new piece of legislation. It was actually introduced in 2000. And the piece of legislation is Chapter 8 of the Income Tax Earning and Pensions Act. And what this piece of legislation did is that it said that where an individual operating through a limited company is in fact operating as an employee, then that limited company has to account to HMRC for any income tax or national insurance payments that should have been deducted from any of the fees paid to that limited company in respect of those services. And under Chapter 8 ITEPA, which we refer to as the old rules, so it's original IR35, the responsibility for deciding whether or not there had been that employment relationship and therefore a charge to income tax, that sat with the contractor and their own limited company. So HMRC were very dependent on those contractors at the end of the tax year holding their hand up and saying, actually, these engagements that I've been working on over the last year, I was working as an employee, and therefore I should have paid income tax and national insurance contributions on the income that I received for those services. So as you can imagine, what happened was many contractors actually weren't holding their hands up, funnily enough, and the government sort of reviewed the situation. I think they determined that it was something in the region of 90% of contractors that weren't complying with the original IR35 rules. How they came up with that 90% figure, I don't know, but it seems plausible. And so this is what led to the introduction of what we call the new rules, and these are the rules that in the private sector came into force last April 2021. They came into force in the public sector earlier than that in 2017. And what the new rules do is they shifted that responsibility for deciding whether or not it was an employment relationship and therefore charged to income tax away from the contractor and their personal service company and moved that responsibility onto the end client. So under the new rules, under Chapter 10, it is the end client that has a responsibility for, first of all, deciding if there is what we call deemed employment. So in other words, is the relationship one of employment for tax purposes? They do this through having to make what we call a status determination statement and give a copy of that to the contractor. And if the client is the one that is directly responsible for paying the fees for the services directly to that contractor's limited company, then they also have to be responsible for making the income tax and national insurance deductions and payments to HMRC. Sometimes, as many of you may be aware, the supply chain isn't always that straightforward. Often we might have another company in the middle, such as an employment business. And so while the client will always remain responsible for deciding if there is deemed employment, sometimes another entity, such as an employment business, is the one that actually pays the fees directly to the contractor's limited company. And then it's that employment business that will have the responsibility for making pay deductions.
And certainly from our work with our clients, particularly working with those end user clients, one of the key, I suppose, headaches really has been this issue of status and status determination, as you sort of alluded to. And I just wonder, where we are now in terms of what that status determination looks like.
Yeah, you're absolutely right, Emma. And I think this is why when the new rules came into force in 2017 and then in the private sector last year, it caused so much concern within the business sector, because it is such a complicated legal test to decide whether or not somebody is in deemed employment. And what the legislation actually says is that there's essentially a 3-stage process to making this decision. And this is set out on the slide here. So the first step is to decide what the actual contractual arrangements are between the consultant's limited company and the end client. So you would turn to the written contract, if there is one, to look at what those express terms are. Once you've identified that, you then have to consider what is the hypothetical contract. So by hypothetical contract, what we mean here is that the end client doesn't have a direct contractual relationship with the contractor. The end client will have a contractual relationship with the contractor's limited company. So in order to decide if the relationship between the client and the contractor is one of employment, the courts have to imagine that there is a contract directly between the contractor and the end client. So it has to ignore the existence of the limited company. And this is what we call the hypothetical contract. So it's an imaginary contract. And the courts then have to decide, well, if this imaginary contract existed, what would its terms be? And in making the decision about what those terms are, they can look at the actual contractual arrangements that are in place, but they can also take into account other circumstances, including the way that the contract is actually performed in practice. And so they can take into account circumstances which go beyond the actual written terms of the written contracts that exist. Finally, once they, sorry, Emma.
No, I was going to say, and that kind of fits with what we say in general to our clients, which is, you can have the best written contract in the world, but it's the reality, isn't it, of how the relationship works it's always that in practice.
Absolutely. And I think that's one of the most difficult aspects of this, because there's a degree of uncertainty there. When we've got everything written down and we think we can rely on our express terms, it's all nice and clear and certain. But once we step outside of that and we have to consider all these other factors, it then can become quite difficult. So finally, once we've understood what our hypothetical contract looks like, we then have to apply the employment status test to the terms of that hypothetical contract. And it's that employment status test which has been heavily litigated, is ever evolving, and is very difficult. And this is where a lot of clients have been having a lot of trouble.
Yeah. Well, let's move on then to have a look at what some of those issues have been, particularly around that sort of hypothetical piece. And we've got this mix, haven't we? We've got this mix between what the courts have said for somebody who we would regard as an employee, And then we've got this conflict between who we would regard as an employee for tax purposes. And it's a slightly different model, but obviously all we have is really sort of the legal tests, which have come out from, you know, cases back in the 70s. So we've got here the ready mixed concrete case, and we've got the sort of the three-step test there, Katie, with regards to employment status. So how would this work?
So yeah, I mean, and it's a very interesting, I think, relevant point to make, Emma, that there is sort of this overlap between employment status for tax purposes and employment status for legal purposes. They are very different things, but the law and the test that you apply is pretty similar, if not the same, for both things. And the reason for that actually is because employment status is statutory. So there are very clear statutory definitions in our legislation as to what is an employee and what is a worker. Yeah. But we don't have that for tax. All that tax says in the tax legislation is that there must be personal service, but that's it. It's silent. Mm-hmm. So for tax purposes, the courts and tribunals really have drawn on the case law that has been developed when looking at the employment status for statutory purposes. And so that's why we've got this big overlap. Now, the leading case, which has been around for years and years and years, but it's widely recognised as being the leading case for employment status, is the case of ready mixed concrete. And what this essentially decided was that whether or not someone is, well, the test for employment status is as follows, and I'm going to just read quickly from the case itself. First of all, the servant agrees that in consideration of a wage or other remuneration, he will provide his own work and skill in the performance of some services for his master. Number two, he agrees expressly or impliedly that in the performance of that service, he will be subject to the other's control in a sufficient degree to make that other the master. And finally, number three, the other provisions of the contract are consistent with it being a contract of service. So this is an old case and it's very archaic language there. We're talking about master and servant. But essentially what it boils down to is that there are sort of three core strands to whether or not somebody is an employer. The first is the requirement for personal service. So this means the requirement to provide your services personally to the employer. You can't, for instance, send, you know, your friend Bob in your place. It has to be you that provides that service and nobody else. Secondly, the requirement for mutuality of obligation, as it's become known. Now, this is a very tricky and thorny concept, and as we'll go on to see in a moment, there's still a huge degree of uncertainty over what this means. But fundamentally, it means reciprocal obligations. So in the work context, it would be the obligation to provide work and the obligation on that individual to perform that work if provided. Control is the second step. So that is the level of control such as to make the individual the servant of the master. So it's control over what the services are, how they're performed, where they're performed, when they're performed. So ultimate control. And then finally, other factors that are consistent with employment. And we'll go on and have a look about what those other factors are in a moment, because this is the third stage of the ready mixed concrete test, has been heavily litigated and developed over the years.
Okay, so let's go on and have a look at some of those issues then, Katie. So here we've got some cases, haven't we? And some of you may have, heard about these cases that have come through, but we've got some sort of key decisions there. How have they impacted the ready mixed concrete test?
So what they've done is they've actually drawn and developed further that sort of three-stage test, if you like. And Weight Watchers is the first point, which basically says that once you have established that there is personal service, mutuality of obligation, and a sufficient degree of control, Weight Watchers says that if those three things are satisfied, then there is a presumption in favour of there being an employment relationship, unless there are other factors in the contract which are inconsistent with it. So it's very much saying that there is, that there is this presumption something will be an employment contract unless you can prove it isn't, essentially, if those first three factors are satisfied. This was developed further by the case of market investigations, which looked quite closely at that third stage test and this concept of other factors. What do we mean when we're talking about other factors? And what the market investigations test said is essentially what we're looking at is whether an individual is carrying on in business on their own account. So this is where the business on your own account test, which is, again, we'll see, is now quite important, sort of started to come into play for the first time. And what this means is looking at factors outside of the contractual terms, if you like, to see what that individual, how they are carrying on their business more generally. So, for example, do they have other clients? Do they invest in their business? Do they advertise their services? Do they carry financial risk in the provision of the services? All those sorts of things, because obviously all those sorts of things are very inconsistent with employment status. You wouldn't expect, for instance, an employee to take the financial risk of undertaking their work, but you would expect that from somebody who is self-employed. Hall versus Lorimer again went on to develop this further, and what the court said in this case was that actually, when you're considering all these different elements of the employment status test, it's really important to stand back and paint a picture from the accumulation of detail, they said, rather than carry out a sort of a tick box approach. So it's not a simple case of going, yes, that's been satisfied, yes, that test is satisfied, yes, that test is satisfied, okay, it's definitely employment or it's definitely self-employment. What Hall versus Lorimer said is you have to stand back. It's very much a holistic assessment of the full picture once you've got all the facts and circumstances and all of the details. Autocleanse and Belcher is a case that again looked at, when we're deciding what the terms are of this hypothetical contract, as one of the ways we do that is to look at the terms of the written contracts that are available. And as many of you on this call might be aware of, often you see in our consultancy agreements, we might have a clause in there that says very clearly the parties do not intend this to be an employment contract. The parties agree that this is self-employment. And what the court in Autocleanse and Belcher said is that actually, if there are terms in a written contract which are inconsistent with the reality of the relationship, those written terms can be disregarded. And so an example for this might be when we're talking about substitution clauses, for instance. So as I mentioned earlier, one of the key tests, or one of those three sort of crucial elements of employment status, is the requirement for personal service. So a lot of people think, well, if we put a right to send a substitute in place of the contractor into a contract, there is no right, or requirement for personal service. Excellent, we can get around the employment status issue. And so following the decision in Autocleanse versus Belcher, actually that isn't going to work unless that substitution clause is a genuine clause and there is evidence that it can and will be used in reality. And this principle was followed most recently in Uber. Same principle, there was a statement in the contracts for Uber stating that the Uber drivers were self-employed, and the Supreme Court said, no, we don't need to, we can disregard that. It clearly doesn't reflect reality.
Absolutely.
So some interesting sort of developments there, but we don't, still yet have a full picture, and it's there's still a lack of clarity around some aspects even now. So there are some thorny issues that exist and some inconsistencies. So the first of these, as I mentioned them earlier, is mutuality of obligation. Now, as we've looked at, that is one of the key sort of first two elements of the employment status test under ready mixed concrete. And under Weight Watchers, if it exists and we can tick that box and there's sufficient control, there will be a presumption in favour of employment. Well, no one's very clear on what mutuality of obligation actually means. Is it just the obligation to pay for work if it's provided? You could argue that any contract has mutual obligations within it, because that's the very essence of a contract. But just because a contract exists doesn't necessarily mean it's one of employment. So do you need something more to satisfy that mutuality of obligation test for status purposes? And secondly, there has been some tension over the ready mixed concrete test being very much a three-step test, and this concept of, well, actually it's multifactorial and we need to consider all of the circumstances in one go. So which is it? Is it a three-step test, or is it, we consider everything in one go? So this brings us quite neatly on to the most recent developments. So some big decisions which have come out over the last year, and these have sort of has much hope that these decisions would tackle some of these issues. So the first case is PGMOL, which stands for Professional Game Match Officials Limited, and this was a Court of Appeal decision that came out in September. And this case concerned the use of referees who were sort of part-time casual referees. They undertook refereeing really as a hobby in their spare time alongside sort of full-time paid employment. And HMRC took PGMOL to court over this on the basis, they said, well, actually these referees are employees for tax purposes, and the match fees that you've been paying them should have income tax and national insurance deductions made from them. And so this went to the first tier tax tribunal and the upper tribunal, who both decided that actually no, these referees were not employees for tax purposes. And the reason that one of the reasons that they decided this was they said there was insufficient mutuality of obligation in the relationship for the relationship to be one of employment. Now, the reason that both those courts reached that conclusion was because they found that the terms of the contract allowed the referees to cancel their matches at any point up to when the match started. And they also found that there was absolutely no obligation on PGMOL at all to offer the referees any matches. And so what the upper tribunal and the first tier tribunal decided was that, there was an overarching contract with the referees that, PGMOL would, from time to time offer them refereeing matches. And there was a separate contract in relation to each individual match or assignment that the referees would undertake. In respect of the overarching contract, there was absolutely no obligation or mutuality of obligation at all, simply because no obligation on PGMOL to provide matches, no obligation on the referees to undertake them. And that followed that because the referees could cancel a match at any point up to performance of it, there was no mutuality of obligation. Now, this caused HMRC quite a lot of concern, and one of the main reasons for this is because the employment status tool known as CEST, which is HMRC's sort of flagship, much lauded tool to help employers decide whether or not somebody is or is not employed for tax purposes, relies on the assumption that there is mutuality of obligation in every single contract. So this decision was crucial for HMRC because if it went in the wrong direction, it effectively meant that CEST was fundamentally flawed, because this concept of mutuality of obligation isn't assumed to exist in every single contract. So HMRC appealed, and the Court of Appeal looked at this and decided that actually it agreed in some respect with HMRC. But what it actually said was that the fact that the terms permitted either side to cancel the contract before it had been performed was immaterial. The contract existed together with its mutual obligations right up until the point it is terminated. And the Court of Appeal said that actually the first tier tribunal and the upper tribunal had confused the issue of, whether there's mutuality of obligation in an overarching contract with the question of whether there can be mutuality of obligation in relation to individual assignments. And so what the Court of Appeal did is it sent the case back to the first tier tribunal to be determined, with a direction that they need to focus their minds on whether there's sufficient mutuality of obligation in respect of each individual assignment. So the decision is unsatisfactory from our perspective because it doesn't really give us any greater guidance. The Court of Appeal very much missed the opportunity to shed further light on this. HMRC have, lauded it as a win for them because the Court of Appeal seemed to be persuaded by their argument. However, the Court of Appeal did stop short of making a decision in HMRC's favour, and actually what they have done is it has directed the upper tribunal to consider, in light of all the facts, is there sufficient mutuality of obligation in respect of each assignment, which suggests that this concept of there being a presumption isn't entirely correct. So I don't think it's quite the slam dunk that HMRC has said it is, but it's certainly interesting. It'll be very interesting to see what the upper tribunal decides. Finally, Kickabout is another case, April 2022, again looking also at mutuality of obligation, but this was much more fact specific, and it just shows how decisions can vary depending on the facts. And in this, the Paul Hawksby, radio presenter of TalkSport, he was pursued by HMRC, and he actually won his position initially at both the first tier tribunal and the upper tribunal, who both decided that he wasn't employed because there was insufficient mutuality of obligation and also a limited amount of control over him. So the radio presenter, wasn't able to control what he did while he was presenting his programs. And this was appealed by HMRC to the Court of Appeal, who actually came down on HMRC's side on this one, and decided that actually, it was right that TalkSport did have to offer a minimum number of programs. So therefore, there was some obligation there, and there was ultimately the radio that the TalkSport had ultimate control over the content of the programs. So it didn't really matter that they didn't have much control over what Paul Hawksby said or did while he was presenting. There was this concept of having this overall control, which was sufficient.
No, it's interesting developments there. And I think, it's funny, isn't it? We seem to sort of go 2 steps forward with the case law and then, sort of 3 steps back. And I think this next case as well. And we have seen, quite a few high profile, people in the media and entertainment who have, either been caught short or have been found to be, yes, working on their own account and merely sort of, actors and playing a persona. How does this case sort of fit with the other cases?
That's absolutely right, Emma, and I think it's it just goes to show as well the differing decisions by all of the courts all through this. The courts can't seem to agree themselves on how this test should be applied. So this next case, Attle House, is actually one of the biggest and most important decisions that has come out over the last year on employment status, and this concerned Kay Adams, who's a BBC presenter. I think she's been on Loose Women, but she does lots of different things. So she writes books, she freelances, presents for sort of news and things like that. And HMRC basically appealed to the Court of Appeal against earlier tribunal determinations that she was outside of IR35. And so the Court of Appeal have looked at this, and actually the reason why this case is so significant is because it is one of those cases that actually does give us some much needed clarity on how to provide this three-stage test under ready mixed concrete. So those sort of difficult issues that I talked about earlier, thankfully the case of Attle House has helped us with this. Now, the first thing it looked at is the question over whether it is correct, so as we saw in some of the earlier cases, to ask the question or to approach employment status by asking the question whether someone is in business on their own account. HMRC challenged this and said, no, that's the wrong way of looking at it. You need to follow the three-step process under ready mixed concrete before you get to that question. And the Court of Appeal rejected HMRC's submission on that point and said, actually, this is just a way of restating that other factors test, stage 3. There is nothing wrong with approaching it by saying, asking in the first instance, is somebody genuinely in business on their own account? The court further sort of went on to say that the three-stage test under ready mixed concrete, it clarified that the first 2 steps, so personal service, mutuality of obligation and control, they are prerequisites for a finding of employment status. So if those things, if either one of those things don't exist, then there can be no employment status finding. But once you've ticked those boxes, if you like, you then have to stand back and as Hall versus Lorimer explained, make an overall assessment of all the facts to then finally decide, is this employment or is this self-employment? Another of the things that HMRC challenged Attle House on and the early decisions on was whether or how far the court can look at factors outside of the terms of the contract. So if we remember, part of the market investigations test was to look at this business on your own account point and looking at whether there are other clients, whether there is investment in services, and certainly in Kay Adams' case, she had lots of other clients. She invested heavily in marketing, and HMRC tried to argue that the court shouldn't look at those things. The court should purely be focused on just the terms of the relationship itself and the terms of the contract. And again, really helpfully, the Court of Appeal rejected that argument and said that you must have regard to these other factors and these other circumstances. It's perfectly acceptable to do that, and it's highly relevant to do that to decide when we're looking at that third stage test. But the Court of Appeal did clarify that we can only consider factors up to the point of the engagement. So it can only be facts and circumstances that the parties were aware of at the time they entered into the contract for services. So in Kay Adams' case, she tried to point to services and work that she'd undertaken after her time with BBC as evidence that she was in business on her own account. And the Court of Appeal said, no, you can't rely on that. You can only rely on everything that happened up until the point that you were engaged with the BBC. Finally, and quite significantly, and I think quite helpfully, the Court of Appeal rejected the position adopted under the Weight Watchers case. Now, if you remember, in Weight Watchers, the court said that once you had satisfied the first 2 steps of the ready mixed concrete test, there was a presumption in favour of employment. And actually, the Court of Appeal in Attle House has said that's not correct. That isn't the correct position. There is no presumption in favour of employment. The 3 factors, as I said, are a prerequisite. At the third stage, you then need to stand back and consider. So you might, even if you have those first 2 tests satisfied, it can still be a contract, self-employed contract, if all the other factors point in that direction. So that's a really, I think, a really helpful clarification. Certainly helpful for employers and contractors who are providing their services.
So do you think this will be the sort of the gold standard now? This will be the decision that the courts will follow, or is this likely to be further appealed?
I think that definitely the factors that we've just talked about. I mean, this is, yes, absolutely the gold standard now. This case is now going to be considered the leading case on that ready mixed concrete test. I think the difficulty with it is that, again, it didn't really help us with understanding the mutuality of obligation issue. So that's something that's still very much up in the air, and we're hoping that further case law will clarify that point for us.
So we've talked a little bit about the CEST tool, and as you've highlighted, particularly with the cases involving the referees,
yes,
that and the sort of the talk sport chat, that obviously, you know, CEST works on the basis that, you know, you are an employee until you're proven otherwise. So I guess we've got this conflict now between HMRC's, you know, as you said, much lauded CEST tool, their sort of status determination tool, and obviously where we are in terms of the case law. And I wonder, you know, where do you think that conflict's going to sort of, you know, resolve itself?
Yeah, so it's, you know, it's very difficult, and I think as much as HMRC sort of, you know, have announced the PGMOL decision as supporting CEST, I think that's wrong, and I think a lot of commentators believe that that's wrong as well. It hasn't resolved the issue, and that is just one issue that there is with CEST. You know, so the other issues with CEST, and I don't know if there are many people on this webinar listening in who have tried to use CEST, but the first sort of biggest criticism is it only provides a definitive result in 80% of cases. So there are a lot of cases where it just won't give you any result at all, which is really, really unhelpful. It doesn't reflect the approach to employment status that the courts have taken. We've discussed the fact that it assumes that mutuality of obligation exists. But as we've seen, that's a very dangerous assumption to make, because it is one of the fundamental prerequisites to employment. But there is still a huge degree of uncertainty over whether that is the correct position. And in fact, I would argue that it's not, because, you know, if it is simply, is there enough mutuality of obligations so that a contract exists? Well, that doesn't make sense, because, you know, a contract can equally be a contract, a self-employed contract, as much as it can be a contract of employment. So there has to be something more. It's just a question of what that something more looks like. And it doesn't recognise this multifactorial approach that the Court of Appeal has, you know, ratified in the Atoll House decision. It applies this kind of, you know, and again, if anyone listening in has actually used CEST, it is very much a tick box, yes or no, which is the very approach that that the Court of Appeal has said, no, that's not the right way to look at it. And finally, the questions are really misleading and very easy to answer incorrectly. And one of the examples of this is around the right of substitution. Now, as I've sort of mentioned earlier, personal service is one of the fundamental prerequisites for finding employment status. If there's no personal service, there is no employment finding. And, you know, when you play around with CEST, you'll notice that this question in particular is fundamental. If you answer it no, then you're going to get an outside IR35 determination. If you answer it yes, you will most likely get an inside determination. So this is a fairly fundamental question. But when you read it, and it's that latter paragraph there where it says this can include rejecting a substitute even if they are equally qualified and meet your interviewing, vetting and security clearance procedures. Well, that tends to imply that if you reject a substitute because they're not equally qualified, that means that that you have an ultimate right to reject a substitute. But actually, the case law has said that having an ability to reject a substitute because they're not suitably qualified doesn't mean there isn't a requirement for personal service. That's actually permissible to do within the case law. So what you will find is that lots of clients will, answer yes to this question, and it will come up with an incorrect result because it doesn't reflect what the case law is saying.
So I think, I get it. I understand, the background to it. I get the point about, you can't have people marking their own homework, and surprise, surprise, I think it was 90% of respondents were, well, surprise, surprise, not caught by IR35. So I get all of that. But obviously, something hasn't worked. And we've seen that, in the case law, and we've got this conflict between obviously what HMRC says, what the case law says, and obviously, the reality of how this is all sort of working. So, we have had, we obviously know that there are some criticisms about it, and we've talked about some of those. It's very complex. It throws up these sort of like, weird and wonderful results, particularly as you've highlighted there, Katie, with the CEST tool. And I love that point there. HMRC have lost more tribunal cases than they've won. So obviously, there is something that hasn't worked. And I do think your point there about disruptive to business, I think disruptive for everybody, isn't it? Disruptive for the, the contractors and for those agents, there's often those other sort of, parties involved in the supply chain. It's not as perfect as, contractor that works a personal service company and is then engaged by a client. Again, it's that sort of the imperfect, trying to fit within sort of, perfect world of legislation. So obviously it hasn't, and it has been incredibly disruptive for businesses, particularly, as they're having to sort of grapple with these SDS determination status certificates. So, we've had an announcement, haven't we? And then, as we've seen, there's some of those unintended consequences as well. You say there's sort of the reaction from the banking sector. How's that been impacted by this? Sort of
so one of the things we've seen, since this was introduced into the private sector is clients are taking different approaches to it, but a lot of them have become very risk averse to it, because obviously they don't want to get this wrong, because the liability can fall back onto them. Absolutely. If they get the status determination statement wrong. They'll just make a finding that people are inside IR35 generally. They don't want to take the risk of employing someone outside IR35. And the banking sector in particular actually just had a complete black ban on using contractors at all.
Wow.
So, that was a very big change to the labour sector. There's been an increase in the use of umbrella companies and statements of works, and umbrella companies in particular are, HMRC have warned businesses about using umbrella companies. So they're a company that will sit in the middle and will effectively employ a contractor in behalf of a client and make the payroll deductions. But the difficulty with umbrella companies is that a lot of them will try and offer tax-friendly ways of getting around the income tax, which is essentially tax avoidance. There are a lot of good umbrellas out there, but there are also a lot that of non-compliant umbrellas, so that can be very dangerous. And absurd results as well. So HMRC compliance activity, it's particularly in the public sector, have resulted in huge tax bills for the Department for Work and Pensions and the National Audit Office. And the irony is that both of them were trained by HMRC and used CEST. So, I think these unintended consequences, I think, probably just lead us quite naturally to where we are now. This wasn't working at all, and something needed to be done about it.
And obviously those figures there, that 88 million and 260, that's taxpayers' money, isn't it? The money that, it's those sort of figures are, again, staggering. So obviously we've had an announcement, haven't we? We knew that there were going to be some rules and some sort of, legislation that was going to be looked at. And I guess because this only came into force last April 2021, and don't forget it was pushed back, wasn't it? Because this was supposed to come into force in obviously April 2020, and we all know what was going on there. So we pushed it forward to April 2021. So really, we should, I guess, still be in a bit of a honeymoon you know, period with IR35. But obviously, you know, we had the statement last week in the budget that it, you know, it is going to be looked at, and whether that's a complete, you know, let's just get rid of it, back to the drawing board, or let's sort of, you know, try and replace it. And again, that's going to be for the public sector and the private sector as well. So there's sort of, you know, a bit of a double whammy there. So can we sort of shed any light, Katie, on what this might actually mean in practice?
Sure. Yeah, so I think the important point to just confirm here is that yes, there's been an announcement of an intention to repeal the new rules that came into force last year, but this will not be confirmed until it's, you know, the legislation or proposals have received royal assent, which isn't going to happen until sort of February, March time. Until then, anything could happen. So, you know, we aren't quite at, you know, the fat lady singing yet. We still don't 100% know that this is definitely going to happen, although there's no reason at the moment to anticipate why it won't. The other important point to make is that the repeal is not of IR35 in full. The repeal, if you remember when we go back to the beginning of the session, we talked about the old rules under Chapter 8, where the responsibility sat with the contractor and their limited company, and the new rules under Chapter 10. It's only the new rules that are being repealed. So IR35 will still exist. It's just that the responsibility and liability for determining if tax should have been applied will no longer be with the client or with any other businesses in the supply chain, such as employment agencies. It will only sit with the contractor again. So it's a reversion back to how things were rather than a complete repeal. And finally, you know, they're going to have to do something, because if they're right and actually there was widespread non-compliance with old IR35 because contractors simply weren't putting their hands up, and, you know, the government estimated that, you know, the non-compliance cost the Exchequer 440 million in that one tax year. Well, you know, what are they going to do? Are they just going to carry on and accept the non-compliance? Clearly old IR35 wasn't working. I think more likely they're going to have to look at putting something else in its place. So I think this is very much watch this space. It's certainly not over for IR35 yet.
I think you're absolutely right. I think, you know, yes, end clients can sort of, you know, at the moment, or from maybe April of next year, you know, maybe sort of breathe a small sigh of relief. But obviously, you know, end clients will still have the issue with regards to individuals that they engage, you know, without a personal service company. You know, let's not forget, you know, IR35 is just about those intermediaries, those personal service companies. If you are engaging freelancers, you know, contractors, you know, temps, you know, those issues of status, those issues of tax are still very much, you know, on the HR.
Absolutely. And you know, and the chances are that if HMRC are, you know, losing revenue because they've rolled back the IR35 reforms, well, they're possibly going to be looking at other places to recover that. And one of the places might well be focusing on all off-payroll workers. So not just those working through a limited company, but those engaged as sole traders. You know, that's probably going to be a big area of focus for HMRC as well. Perhaps random audits, I don't know, but it's certainly going to be the thorny issue of employment status is going to continue. Absolutely. And very frustrating as well, I think, that this sudden announcement of repeal, because a lot of clients would have spent a lot of money putting processes in place and adapting their labour supply chains, and will now have to spend time unpicking all of that.
And training as well.
Training, contracts will probably need to be changed as well.
Exactly. So, but again, you know, although perhaps, you know, the sort of the formal status determination certificate, you know, bit might go, actually the fundamental principles of who have you got working for you, how are they working for you, you you know, how long have they been working for you, in what capacity, you know, let's go back to those tests, you know, are they in business on their own account, are they genuinely part of the furniture now, you know, what email account do they have, what do you give them, vans and tools and laptops and phones and all, you know, all that. It's still incredibly relevant.
Yes.
Even if you take out the, you know, we're going to fill out a form and we're going to send it to you and you can agree or disagree whether you're, you know, inside or outside IR35. So I think, you know, even though it's a great headline grabber, I think for people who do work through personal service companies, you know, it might be, you know, back at you. But I think for those organisations that engage as well, whether through PSCs or individually, you know, there is going to have to be something that's going to have to, you know, replace what's currently there. And, you know, we've seen, haven't we, issues around employment status. You know, I mean, goodness me, we're in 2022 and we still don't really know, you know, what is an employee. You know, it's that sort of elephant in the room. Looks like a duck, quacks like a duck, you know, maybe it's a duck. But, you know, again, we are still struggling with that. And we can see that, you know, some brave soul has decided to, you know, put forward a private members bill.
It is, that's right.
A private members bill, which sort of helps to sort of shed light on this. But, you know, goodness me, we've got definitions, obviously, in the Equality Act. We've got definitions in the working time regulations, which I'll sort of come on to talk to. We've got regulations, haven't we, in the Employment Rights Act, you know, unfair dismissal rights, etc., etc. So we've got all of these different definitions. I mean, what's the purpose of this bill, apart from, you know, trying to give somebody a bit of more of a headache?
I think it's you know, it's just following on from the Taylor review and following on from all of the complicated case law that we've seen. And one of the fundamental criticisms, I suppose, of IR35 is that people are being, you know, find themselves being taxed like employees, but they're not getting the benefits that they would be getting, which seems incredibly unfair. And I think this is an attempt to try and simplify the test. You know, so for statutory purposes, for legal purposes, you're either an employee or you're not. And that's it, which is very similar to the position we have in tax at the moment. You're either employed or you're self-employed. The difficulty at the moment is that we have this other category of worker, and, you know, and that sort of complicates factors. So that's the purpose of this bill, to try and have just the one definition, the one test. So we don't have workers anymore. We just have employees or not. And the wording of the bill, I've had a look at it. It's very much draft at the moment, but it tends to say that essentially an employee is somebody who is not operating in business on their own account. So it's back to that crucial question again, which has been developed by the case that we've been talking about. And also it includes a presumption in favour of employment. So there's almost this burden of proof here for employers to have to prove that somebody is self-employed. So again, you know, it just assumes that everyone is employed unless there's evidence otherwise. Will it work? Who knows? I think I saw a quote recently who likened, you know, the trying to figure out a simplified employment status test to solving world peace. You know, it's that level of difficulty.
It seems to be sort of something that, you know, courts have been trying to do for years, you know, and it's one where obviously it's the pace of change and how people are working, and, you know, people like that flexibility, you know, working as and when they want to, you know, that sort of balance against, you know, trying to sort of drag the law and drag definitions to sort of keep up with the pace of change, as we've seen, obviously, you know, in the gig economy and the cases that are coming up, you know, Uber and Deliveroo, and the sort of various delivery Addisonally as well. So it's one where I think, you know, watch this space, and whether it will, you know, mean that we will have to sort of go back and look at all the other legislation where we do have some sort of definitions, whether it will be, you know, what's going to happen in reality. And just before we close, I do want to sort of flag to you, I mean, obviously, you know, the budget as well, the mini budget, which came out last week. So we've got lots of sort of tax issues and things like that for employers to think about. But I think one one piece of legislation that may have escaped you, which wasn't in the budget, but actually was published separately to that, is the snappily titled, retained EU law bill. And this could be potentially huge and have huge implications for workers, employees, workers' rights, red tape for businesses, etc., etc. The aim, as we've heard, is to, try and remove some of the pressures on businesses to get people investing, etc., etc. That's the sort of the thinking behind it, and obviously, post Brexit, etc., etc. So I've put on here some of the the pieces of legislation, like EU derived law, so those regulations that we have that we have retained post Brexit. There's a few of you there that will raise some eyebrows. There are a few of you that might be sort of wanting to sort of whoop and cheer. There may be potentially no love lost for agency workers regs and fixed term workers regs, but working time's pretty fundamental, and obviously TUPE as well. How are we going to protect those individuals that do transfer when employers change? So the theory behind it is that now government departments will go away and look at, and I was reading sort of, I think it's 2,400 pieces of legislation, rules, etc., have been flagged as potentially being looked at. But the plan is that, it's keep it or lose it. So, unless those rights or parts of those laws or parts of those rights are enshrined into UK only law, and unless that's going to happen by December next year, then they will be automatically repealed. So some huge implications there. Lots of work to be done, obviously, in various departments. Fear not, that December 2023 date is not a final date. It can be extended to December 2026. So, we will have to wait and see, but some massive changes there potentially on the horizon. And, thinking about how quickly this year has gone, December 2023 is not a huge time to have to wait for potentially some of our laws, love them or hate them, potentially to go or to be enshrined in a different way. So get involved in consultations when they come up. Lots of issues there to think about. Again, we saw some issues there in the budget as well. Interested in those sort of new investment zones that were announced. Some interesting places there that can see some real investments. So some exciting times ahead there, hopefully. And obviously, we saw some changes, didn't we, to national insurance rates that will be very relevant there to employers. So lots happening, and again, we might see some anti-strike rules changing, wanting to bring in agency staff there where you've got staff that are striking, and also some changes there potentially. We don't know anything about it. Certainly there were some mootings in the leadership hustings around some changes there to strike legislation. So again, we will have to wait and see. So thank you very much for joining us today. My thanks to Katie. Goodness, that was a lot to talk about there. So thank you so much for sharing all of that with us. If you do have any questions about IR35, if you want us to come and have a look at what you're doing, what you're not doing, how you could do it better, helping your managers, grapple with all this, helping your HR teams particularly grapple with what they're going to have to be grappling with for a few more months to come, and obviously what lies ahead, then do get in touch. Looking forward to catching up with everyone on our next webinar. But if anyone's got any questions they want to raise, or they want to sort of get in touch, then do contact Katie and I. I'll be sending out the recording, so you will get that, which you're able to share. Do check out our YouTube channel. You can see all our back catalogue of webinars that we have done, and also our blogs as well. So hope all's well, and looking forward to seeing you all soon. Thank you very much, and goodbye.
Goodbye, everyone.